This is a breaking immigration update that every green card holder needs to hear right now. If you are a lawful permanent resident, if you have family members with green cards, or if you're currently outside the United States, what I'm about to share could directly affect your ability to return home. Reports are emerging from airports and border checkpoints across the country that some green card holders are being stopped, questioned extensively, and in certain cases, having their re-entry into the United States delayed or challenged by Customs and Border Protection officers. This is happening to individuals who hold valid, unexpired green cards and who believe their return to America was guaranteed. Let me be clear from the start. This does not mean that all green card holders are banned from returning. This is not a blanket policy affecting everyone. But what is happening represents a significant shift in how immigration authorities are exercising their enforcement discretion at ports of entry. And millions of lawful permanent residents need to understand what this means for them. In this video, I'm going to walk you through exactly what is happening, why it's happening, who is most at risk, and most importantly, what you need to do to protect yourself and your family. This information is based on official DHS policy guidance, reports from immigration attorneys across the country, and documented procedures at U.S. ports of entry. Stay with me until the end, because I'll explain the specific documents and evidence you need to have ready, the common mistakes that are putting people at risk, and how to navigate the situation if you're already outside the United States. Let's break this down. First, we need to clarify what we're actually talking about when we say re-entry is being blocked or challenged. This is not a formal ban. The U.S. government has not issued a policy that prohibits all green card holders from returning. What we are seeing is an increase in enforcement actions at the discretionary level during the re-entry process. When a green card holder arrives at a U.S. port of entry, whether that's an airport, land border, or seaport, they are subject to inspection by Customs and Border Protection officers. Many people assume that having a valid green card guarantees automatic admission. That assumption is incorrect. What's happening now falls into several categories. Some returning residents are being sent to secondary inspection. This is a more detailed interview process where officers examine your documents, ask questions about your residence, travel history, and intent to live in the United States. Secondary inspection can last anywhere from 30 minutes to several hours. In other cases, individuals are receiving what's called deferred inspection. This means you are allowed to enter the United States temporarily, but you are required to appear at a local CBP office within a specific time frame to complete your inspection. Your admission is not finalized until that appointment is completed. More seriously, some green card holders have been denied boarding by airlines abroad before even reaching the United States. This happens when airline systems flag potential admissibility issues based on travel patterns or other factors. And in the most severe cases, some individuals are being refused admission at the port of entry itself. This can result in being placed in removal proceedings or being given the option to voluntarily withdraw your application for admission and return to where you came from. All of these scenarios are legally permissible under current immigration law. CBP officers have broad discretionary authority to determine whether a returning resident should be admitted, and that authority is now being exercised more stringently than in previous years. To understand what's happening, you need to understand the structure of U.S. immigration enforcement. The Department of Homeland Security, or DHS, oversees immigration matters through several agencies. Customs and Border Protection, CBP, manages all ports of entry. U.S. Citizenship and Immigration Services, USCIS, handles applications and petitions, and Immigration and Customs Enforcement, ICE, handles interior enforcement. When you return to the United States as a green card holder, you are being inspected by CBP officers. These officers are trained to determine whether you are admissible to the United States. Admissibility is not automatic, even with a green card. The law gives CBP officers the authority to examine whether you have maintained your permanent residence. If an officer believes you may have abandoned your residence, they can question you extensively. They can review your documents. they can place you in secondary inspection, and they have the authority to issue a notice to appear, which initiates removal proceedings. This discretionary power has always existed. What has changed is the frequency and intensity with which it is being applied. According to immigration attorneys, there has been a noticeable increase in scrutiny, particularly for individuals who have been outside the United States for extended periods or who have weak ties to the country. The policy framework being implemented emphasizes verification, documentation, and intent. CBP is no longer taking at face value that a green card holder intends to maintain permanent residence. They want proof. They want evidence. And if you cannot provide that evidence at the port of entry, you may face significant delays or challenges to your admission. Let's talk about why this is happening to certain individuals. Immigration attorneys report that the most common reason for re-entry challenges is prolonged absence from the United States. If you have been outside the country for 6 months or longer, CBP officers may begin to question whether you have abandoned your permanent residence. If you've been gone for a year or more, that scrutiny intensifies significantly. Even if you have a re-entry permit, extended absences can still trigger detailed questioning. But it's not just about how long you've been gone. It's also about your pattern of travel. If you are spending more time outside the United States than inside it, if you only return for brief visits, if you don't have a U.S. residence, employment, or family ties, these factors create a profile that CBP views as inconsistent with maintaining permanent residence. Criminal history is another major factor. Even if you have already served time, paid fines, or completed probation for an old offense, CBP officers can review your criminal record during re-entry. Certain crimes can make you deportable or inadmissible, and officers have the authority to initiate removal proceedings if they discover disqualifying offenses. Immigration attorneys also warn about inconsistencies in your application history. If you applied for benefits as a U.S. resident, but have been living abroad, if you claim tax exemptions or benefits in another country, if your statements to immigration authorities conflict with your actual behavior, these inconsistencies can be flagged during inspection. Misuse of re-entry permits is another issue. A re-entry permit allows you to remain outside the United States for up to 2 years without being presumed to have abandoned your residence. However, if you repeatedly apply for these permits, never establish meaningful ties in the U.S., and use them simply to maintain your green card while living permanently abroad, CBP may determine you are abusing the system. Finally, certain travel patterns raise red flags. Frequent trips to countries with known immigration fraud issues, traveling under circumstances that suggest you are working abroad without proper authorization, or traveling with large amounts of undeclared cash or goods can all trigger additional scrutiny. What we are witnessing is part of a broader enforcement trend. DHS has made it clear through policy guidance that immigration law will be enforced more strictly across all categories. This includes not just undocumented individuals, but also lawful permanent residents who may not be in full compliance with the terms of their status. According to official procedures, CBP has been directed to increase verification efforts at ports of entry. This means more questions, more document reviews, more secondary inspections. The goal, as stated in policy guidance, is to ensure that individuals entering the United States are admissible and that lawful permanent residents are genuinely maintaining their residence. This enforcement is not random. It is targeted based on risk factors that CBP has identified. But it is important to understand that even if you do not fit the highest risk profile, you may still be subject to additional scrutiny simply because of the overall increase in enforcement activity. Legal experts emphasize that this policy shift affects certain cases more than others. If you have strong ties to the United States, if you travel infrequently, if you maintain a home and employment here, you are far less likely to encounter problems. But if your situation is marginal, if your ties are weak, if your travel history is questionable, you are at increased risk. If you are sent to secondary inspection, here is what you can expect. You will be taken to a separate area. usually a holding room at the airport or border facility. You will be interviewed by one or more CBP officers. They will ask detailed questions about where you've been, why you were gone, where you live in the United States, what your job is, who your family members are, and whether you intend to continue living here. They will examine your documents carefully. This includes not just your green card, but also your passport, any re-entry permits, evidence of U.S. residence, tax returns, employment letters, lease agreements, utility bills, and anything else that demonstrates you maintain a life in the United States. If the officers are satisfied, you will be admitted and allowed to proceed. This process can take anywhere from 30 minutes to several hours, depending on the complexity of your case and how busy the port of entry is. If the officers are not satisfied, you may be given temporary parole into the United States. Parole is not the same as admission. It means you are being allowed to enter temporarily while your case is reviewed further. You may be required to attend a deferred inspection appointment at a local CBP office. In more serious cases, CBP may issue a notice to appear. This is a charging document that places you in removal proceedings before an immigration judge. If you receive an NTA, you are not being deported immediately, but you are being required to appear in immigration court to defend your right to remain in the United States. At this point, you absolutely need legal representation. Some individuals are given the option of voluntarily withdrawing their application for admission. This means you agree to leave the United States and return to where you came from without going through removal proceedings. While this avoids a formal removal order on your record, it also means you are not being admitted. Immigration attorneys stress the importance of understanding your rights during this process. You have the right to contact an attorney. You have the right to review documents that CBP is relying on. And you should never sign anything you do not fully understand. Let's be very clear about who is most vulnerable to these re-entry challenges. This is not about age, ethnicity, or national origin. This is about behavior and circumstances. Green card holders who have been living abroad for extended periods are at the highest risk. If you obtained your green card but then move back to your home country, if you only return to the U.S. once or twice a year for brief visits, if your children are in school abroad, if your spouse lives abroad, if you own property and run a business outside the United States, you are in a high-risk category. Individuals who travel frequently but have weak U.S. ties are also at risk. Even if your individual trips are short, if you spend 6 months or more per year outside the country, if you don't have a stable U.S. address, if you're not filing U.S. taxes or only filing minimal returns, these factors suggest you are not truly maintaining permanent residences. Seniors and elderly parents who were sponsored by family members, but who frequently return to their home countries for extended visits, are encountering increased scrutiny. CBP officers are examining whether these individuals truly intend to live in the United States, or whether they obtained green cards simply to have the option of visiting family. Dependents who are included on family-based petitions, but who have limited independent ties to the United States, are also at risk. If you received your green card as a derivative beneficiary, if you don't work or attend school in the U.S., if you spend most of your time abroad, CBP may question whether you genuinely intend to reside here permanently. It's important to emphasize that being in one of these categories does not mean you will definitely have problems, but it does mean you need to be prepared. You need to have documentation ready, and you need to understand the risks before you travel. When you present yourself at a port of entry, CBP officers are evaluating several key factors. They want to see proof of U.S. residence. This can include a lease agreement, mortgage documents, utility bills in your name, bank statements from U.S. accounts, property tax records, or a letter from your landlord. They want to see evidence of employment or business activity in the United States. This can be pay-ubs, employment verification letters, business licenses, or tax documents showing U.S. income. They look at your tax filing history. Have you been filing U.S. tax returns? Are you reporting worldwide income as required? Or have you been claiming to be a non-resident for tax purposes while maintaining a green card? Family presence is another important factor. Do you have a spouse, children, or parents living in the United States? Are they U.S. citizens or permanent residents? Do you have custody or support obligations that tie you here? Your travel history matters. CBP can see every entry and exit. They can see how much time you've spent in the U.S. versus abroad. They can see patterns that suggest you are not genuinely residing here. Officers also consider your intent. What do you say when asked where you live? Do you describe yourself as living in the U.S. or living abroad? Are you consistent in your answers? Do your actions match your statements? All of these factors are weighed together to determine whether you have maintained your permanent residence or whether you have abandoned it. If you are planning to travel outside the United States, preparation is critical. Before you leave, make sure you have copies of key documents. Bring evidence of your U.S. residence, employment, and family ties with you when you travel. Don't assume that having a valid green card is enough. If you know you will be outside the United States for more than 6 months, consider applying for a re-entry permit before you leave. This permit allows you to remain abroad for up to 2 years without being presumed to have abandoned your residence. However, understand that a re-entry permit does not guarantee admission. It simply preserves your ability to apply for re-entry. Make sure you are filing U.S. tax returns every year, even if you have no income or minimal income. Your tax filing history is one of the strongest pieces of evidence that you consider the United States your permanent home. Maintain a physical address in the United States. Even if you are traveling, you should have a home, an apartment, or at minimum a stable address where you receive mail and maintain some presence. Avoid common mistakes. Don't tell CBP officers that you live abroad. Don't say you're just visiting the United States. Don't volunteer information that contradicts your status as a permanent resident. Answer questions truthfully, but be mindful of how you describe your situation. If your situation is complicated, if you have been absent for extended periods, if you have a criminal history, or if you are unsure about your admissibility, consult with an immigration attorney before you travel. An attorney can review your circumstances, advise you on what documents to prepare, and help you understand your risks. If you are currently outside the United States and you're concerned about re-entry, do not panic. Panic leads to poor decisions. Instead, take proactive steps to prepare. Gather documentation that proves your ties to the United States. Contact family members and ask them to send you copies of utility bills, lease agreements, or other documents that show you maintain a residence. Obtain letters from employers if you have a job waiting for you. Collect tax returns, bank statements, and anything else that demonstrates your permanent residence. If you have been gone for close to a year or longer, seriously consider consulting with an immigration attorney before you attempt to return. An attorney can assess whether you are at risk of being found to have abandoned your residence and can advise you on the best approach. In some cases, it may be advisable to apply for a returning resident visa from a U.S. consulate abroad, rather than attempting to re-enter with your green card. This is particularly true if you have been absent for more than a year and do not have a re-entry permit. A returning resident visa, also known as an SB1 visa, allows you to apply for permission to return even after an extended absence. However, be aware that these applications are difficult and require you to prove that your extended absence was due to circumstances beyond your control. Understand that preparation is not a guarantee, but it significantly improves your chances of a smooth re-entry. The worst thing you can do is show up at the airport with no documentation, no explanation, and no plan. There are several dangerous myths circulating about this issue, and we need to address them directly. Myth number 1: my green card guarantees my right to enter the United States. This is false. A green card establishes your status as a lawful permanent resident, but it does not guarantee admission at a port of entry. CBP officers have the authority to determine admissibility, and they can deny admission if they believe you have abandoned your residence or if you are inadmissible for other reasons. Myth number 2. Only people with criminal records are being affected. This is also false. While criminal history is certainly a factor, many of the individuals facing re-entry challenges have no criminal record whatsoever. The primary issue is prolonged absence and weak ties to the United States. Myth number 3. This policy applies to everyone equally. Not true. Enforcement is risk-based. If you have strong ties to the U.S., if you travel infrequently, if you maintain a clear permanent residence, you are far less likely to encounter problems. The facts are straightforward. CBP has discretionary authority. That authority is being exercised more frequently. If you fit certain risk profiles, you may face additional scrutiny. But with proper preparation and documentation, the vast majority of lawful permanent residents will continue to re-enter without significant issues. This enforcement trend has real consequences for families. Many green card holders were sponsored by U.S. citizen children, spouses, or siblings. These sponsors made legal and financial commitments to support their family members. When those family members face re-entry challenges, it creates emotional and financial strain on everyone involved. Elderly parents who received green cards so they could be near their children are particularly affected. Many of these individuals still have strong ties to their home countries. They may own property abroad, have other children living there, or simply feel more comfortable spending time in familiar surroundings. Under previous enforcement practices, they could travel back and forth relatively freely. Now those patterns are being scrutinized. Family-sponsored green card holders need to understand that sponsorship comes with expectations. The sponsor signed an affidavit of support, promising to provide financial assistance. The immigrant received permanent residence based on the family relationship. CBP expects that relationship to result in actual residence in the United States, not just occasional visits. For families navigating this situation, communication is essential. Sponsors should stay in regular contact with their family members abroad. They should help them maintain a U.S. address, file taxes, and keep documentation up to date. And they should be prepared to provide supporting evidence if their family member faces re-entry challenges. Immigration attorneys across the country are reporting an increase in consultations from green card holders who have encountered problems during re-entry or who are concerned about upcoming travel. Legal experts emphasize that the law itself has not changed. What has changed is the enforcement posture. The statutes and regulations governing permanent residence have always required that green card holders maintain their residence in the United States. In previous years, that requirement was enforced more leniently. Now it is being enforced more strictly. Attorneys advise clients to document everything. Keep records of your time in the United States. Maintain proof of your residence, employment, and family ties. If you must travel abroad for extended periods, have a clear and legitimate reason, whether it's caring for an ill relative, completing a temporary work assignment, or handling family business. Legal professionals also warn against making assumptions. Do not assume that because you successfully re-entered in the past, you will have no problems in the future. Do not assume that because you have a re-entry permit, you are protected from all scrutiny. And do not assume that CBP officers will accept your word without documentation. If you are placed in removal proceedings, if you receive a notice to appear, or if you are denied admission, seek legal representation immediately. Immigration law is complex, and the consequences of making mistakes can be severe. An experienced attorney can review your case, identify potential defenses, and represent you in proceedings. What we are witnessing is a significant shift in how immigration authorities are handling re-entry for lawful permanent residents. This is not a blanket ban. This is not affecting everyone, but it is real. It is happening, and it requires awareness and preparation. If you are a green card holder, understand that your status comes with responsibilities. You are expected to maintain your permanent residence in the United States. That means living here, working here, filing taxes here, and maintaining genuine ties to this country. If you are spending most of your time abroad, if your ties to the US are minimal, you are putting your status at risk. The key takeaways from this video are simple. Document your US residence, maintain strong ties, file your taxes, avoid prolonged absences when possible. Apply for re-entry permits if you must be gone for extended periods, and consult with an immigration attorney if your situation is complicated or if you are unsure about your admissibility. This is not a time for panic, but it is a time for vigilance. The rules have not changed, but the enforcement of those rules has intensified. By understanding the policies, preparing the right documentation, and approaching your re-entry with care, you can protect yourself and your family. Stay informed, stay prepared, and remember that knowledge is your best protection in navigating these complex immigration realities. If this video was helpful, please share it with anyone who might benefit from this information. Immigration policy affects millions of families, and accurate information can make all the difference. Thank you for watching and safe travels.